Now we have another honored guest who is an English speaking. Please join us. The next honored speaker is Professor of Law at the estimated Vanderbilt University School of Law in Nashville, Tennessee, in the United States of America. Please.
It's a pleasure to be here. I want to thank the organizers who invited me, particularly Morton and Stina. And I would actually like to thank Rick, who warmed you up for English. And as someone who spends my time in the ivory tower, I'd like to thank him for whatever you think of his politics. I think it's, in the US, we don't have politicians who act on principle. And so I would, so I salute you for that. And so I have, in order to return the favor, I have a piece of advice to offer, which is something that's worked in the US in terms of the Postal Service. Since you mentioned the Postal Service is the largest transmitter of drugs in Sweden. You should do what the US does, which is just hire Postal Service workers who use drugs. Comes in, but it doesn't come out, so. All right, I'm going to talk about Google Books, and obviously all of you know Google, but perhaps all of you don't know Google Books or know it well, so let me talk to you about it and its ongoing litigation, and it's monumentally important. Okay, let me just give you some basic facts, since I'm not, sort of people's level of awareness, I think, varies. About 5 years ago, Google started digitizing all the books. Its goal is to digitize all the books in the world. It started modestly working with University of Michigan, Stanford, which is where Larry Page did his undergrad, and then he and Sergey Brin did their graduate work at Stanford. And so basically the program is to copy academic books, right? Research-oriented books. And this is, right, what copyright used to be about, at least in the US, when 200 years ago, when there was a belief in progress. And now progress is sort of old-fashioned, so we talk about creativity in sort of morally neutral tones. But at any rate, I think Google's very smart to copy books, right, that academics will use, a different business model, and et cetera. So that's what they've been doing. And the obvious key copyright fact, which I'm sure all of you do know, even if you don't know much about Google Books, is that they're doing this without authorization, right? So, so far, how many books? 12 million books. No one knows exactly how many books are in the world, something between 20 and 30 million, so give them a few more years. So all languages, anything that's basically in these libraries. And surprisingly, it varies from library to library. There's less overlap than one might think. So all languages and books published in all countries. I think it's an interesting fact that the machines that they use, Google has vans that drive up at night behind these libraries, and they're filled with books, and they're carried off to undisclosed locations. And the machines that are specially built to copy these books, to not break the bindings, et cetera, which is a very good thing, were made in France, which I think is sort of like the lesson of arms merchants, right? They have no country, so. Okay, so and needless to say, there's if you go on Google Books, right, available on your phone, full copies of public domain works, right, it's rather uncontroversial, and then quote unquote snippets of copy protected books. At the same time, Google started cutting deals with publishers. About half the works they've copied are quote unquote orphan works, and I don't know if sort of whether that language is in your argot or not. So basically orphan works are when you don't know who the author is. And needless to say, that sort of, in the end of the day, would be a matter of sort of how much effort you put in finding out. So just leave it sort of ill-defined, as it is actually in the whole litigation and in the whole literature on this. But roughly, it's publishers who've gone out of business, oftentimes publishers who go out of business, or books that go out of print, they return the copyright to the author. Authors die, the ownership passes on just like a house, so you have kids and grandkids who own part of books, they don't know it, et cetera. So that's how you end up with about 6 million copied orphan works. So about 4 years ago, 2 lawsuits started in the US, one by the American Publishers Association, the other by the Authors Guild. The Authors Guild is a class action, which is sort of a unique form of law to the US. Now they're both combined as a class action, which essentially means that the Authors Guild, which has a defined membership of X number of members, says we represent all authors, right? And that's permissible under US law. This is Rule 23 of the Federal Rules. It was meant to, in effect, sue to give power to little plaintiffs with little causes of damage. So for example, if an airline takes advantage of 1 million people and the damage is only $10 each, there's no economic incentive to sue, so they're allowed to get away with it. So the class action is meant to combine all those damages, and then the class, as long as they represent the larger class, right? That's the idea. So the authors claim to represent all authors of all books, right? And so you have to pass the test being similarly situated. Okay, so and as the lawsuits progressed, Google's kept copying. So elsewhere I've written this is both, and seemingly this would be a contradiction in terms, but if you think about it, it's just true, I think, in this case, right? The largest infringement in the history of mankind, personkind, and also the largest contribution to learning, knowledge, etc. Right? So it's very interesting from that point of view that really Google Books is doing what no government can do, arguably, or no government has come close to doing. So that's sort of the upside, right? And indeed, it's breathtaking, not only access to books, but it's a promise of a whole new way of learning, right? So for example, right now it's the case, let's say, with just Google search generally, if you want to know how the flu is traveling through Europe or the US, right, you can track Google searches where people are searching for vaccines, et cetera, and you can see the flu traveling with the searches, right? And so same thing with books, right? We'll now be able to search how words have moved over time from country to country, the intertextual connections between books, just a whole deeper level of knowledge that we just have not had the ability to get to unless, I think we all have someone in their lives who seems to sort of know everything, in which my case was my dissertation director. And, but now you don't need to have that sort of encyclopedia knowledge, right? You can search through all books, search for ideas that have cut through, thousands of years. Okay, so I dare say, right, besides having heart and lungs, we all love books, and so I just think this is awe-inspiring, right? And if you haven't used Google Books, go to Google Books. But as I said, one fly in the ointment, right? It's the C with the circle around it. I was in the minority 3 years ago in the US arguing that Google Books was not fair use. That was their defense, right? Once again, law specific to the US, but my experience is people have a general sense of it. I argued that it was not fair use, not because I didn't think Google Books was a great thing, but because I think you can analyze law separately from what policy conclusion you want to get to, and that's one of my complaints about many of my fellow law professors is they sort of write legal articles like briefs, right? So I argued it's not fair use because it wasn't fair use under the law, even though I thought, well, how else can we get there? So I thought I was vindicated when a couple years ago, settlement came about, right? The plaintiffs and Google were going to agree, we work this out, Google Books will be available to everybody. And the features are extremely complicated of the settlement. It's 1,000 pages. It went to court last fall in New York Southern District. There's over 100 briefs filed, amicus briefs, Department of Justice, Copyright Office, EU, et cetera, sort of every major public interest group. But just the core features are a registry would be created where money would flow in, and basically 3 revenue models, right? Google would give licenses to institutions, and they contemplate sort of every university would have such a license. And down the road, one would expect there to be less books being bought by universities, right? Because space is expensive, books are expensive. So sort of on the for-profit publisher model, read Elsevier, for example. And then book sales, but it's not really sales in an online world. It's sort of you get a license because you can't copy, no first sale doctrine, et cetera. And then ads, but frankly, Google doesn't see this as particularly remunerative because scholars in particular probably don't want ads next to their work. So really they envision this as a model of institutional licensing. Okay, so when I was at settlement conference last fall, I was struck by the Europeans who were there because they are not generally as versed with class action because it's not part of the legal culture except in the US. We're absolutely apoplectic because how can this be, right? How can you copy every single book published in my country and have this available, right? It's on your servers, it's available for searching by anyone all the time. You're making money on this, completely commercial. We haven't authorized this. How on earth can this be legal, right? So that's sort of the fly in the ointment of this otherwise amazing thing. So, and it was sort of flying in the ointment to the judge who said, go back and talk about this, guys. Come up with something better, right? I'm not rejecting it. The problem with the class action settlement is the law is not what's in the public interest. The law is what's fair between the parties, right? And these are all private parties. So in theory, you could do something else fair for the parties and not in the public interest. And that is fine with class action. Although, given the amount of publicity this had at the time, clearly the judge felt the tension, although not strictly within the law. Right, needless to say, the parties love this lawsuit. I mean, love the settlement. And so whereas I thought I was on the right when they first started settling, because I thought, well, gee whiz, Google's arguing fair use. Now they've caved in their settling, they must not really believe in their fair use argument. But it turns out, when you think about it, it's actually a better deal for Google, the settlement, because if books were fair use, if what they wanted to do is fair use, and indeed what the majority of my colleagues in the States argued that it was fair use, what Google Books was doing, then Google Books would have competition, right? Because who would want to get into this business? I don't know at your end, but obviously Amazon, Microsoft, et cetera, right? Whereas under the settlement, in theory, the book owners can license other people, but why would they, right? A duopoly is a very beautiful thing, right? If it's just the money's being divided between the plaintiffs and Google, why let anyone else into the party, right? Because you get competition. So that was part of the concern that pushed the settlement off the table and pushed us toward a second settlement. Okay, under the amended settlement, which is now sort of floating around and, building consensus or not by events such as this, part of the new settlement would be there'd be a fiduciary appointed to handle orphan works, which indeed are the fly in the ointment because by definition, you can't get authorization from orphan works owners. And I don't know if there's what the translation is, but for fiduciary, under fiduciary law in the US, right, the metaphor is you should step into the shoes of the person you're representing, right? So lawyers, doctors have fiduciary duties, right? In normal business, you don't, right? Third-party relationships. So the idea would be maybe the court would go along with fiduciary. Well, the obvious problem is, by definition, you don't know who the orphan works owners are, so how can you step into the shoes? But that's sort of where it's at right now, and it's sort of, we're trying to figure out a solution, so I'm gonna sort of run something by you along those general lines. But whatever the fiduciary will do, nobody's saying that money won't be collected will not be taken into the registry from these orphan works, right? It's half the money, right? So nobody sort of wants to miss out on that. And it's just a question of, do we set up a database? Do we try to do something in escrow account in case orphan works owners show up, even though there's every reason to think very few of them will? So sort of do anything with the money but give it to the plaintiffs is the idea. Okay, so I want to talk to you about another danger that was part of why the settlement got tabled, and it's that the U.S. Copyright Office has been propounding an idea, and there's trying to get into legislation for about 4 years, and it's not in anyone's interest to sort of, lobbies politicians, so it hasn't happened, but if we lived in a world where sort of the public interest came about, we might move in this direction. So let me tell you about it. And I think it sort of fits in nicely with where Google's going and is sort of a better overall solution. It's called the Orphan Works Proposal. And so I just want to consider from this point of view that, let me just tell you my view that Google will win in the US. So whatever you read, bottom line is Google will win. Complicated set of reasons at the end of the day because they'll outlawyer anybody standing. And you might wonder why Europeans haven't sued. Why they are not part of the plaintiff class. Well, I think they have good enough sense to not want to spend $20 million. And so at any rate, Google, this has sort of been their strategy, and everything they do is sort of a bet the company business, right? When you do just a general Google search, you're not searching the internet. You think results are the internet. They're not, right? They're copies of websites on Google servers. Right, so those are unauthorized copies. You then copy them onto your computer. You're actually arguably infringing, but no one sued over that. So sort of the way Google, they're adventurous in that way, and it's a good thing if you think about it. So imagine the world where Google does win in one form or another. Okay, so we're in a general world of Google Books. Okay, so what do you do with orphan works? That's sort of where I'm going with this. And because books have their own sort of set of problems, and part of sort of the law in general is that you want abstract rules that cover all situations, but on the other hand, the world pushes you toward rules that specialize toward particular types of situations. So what I see is that we need a solution that may fit different areas of content. So for example, in a paper unrelated to this, I argue that user-generated content, because most of it's fair use, should have a fault rule applied to it. And this is how I analyze the Orphan Works report of the Copyright Office. I see it in fault terms, and this is as someone who does tort theory. So, and this matters because other than books, right, there's, for example, photographs. There's millions of photographs. Well, they're not signed. People don't put their names on them typically. So Orphan Works by definition. So if you think of the fact that there's 500 million Facebook users, right, 1 out of every 12 or 13 people on the planet, everyone posting photographs, everyone copying everyone else's photographs, none of these are signed. Who owns them, right? So Orphan Works are just exploding in terms of photography. Video, music, and then ephemera, right? Sort of anything that's copyrightable. So all the content you put on your Facebook site, not just photographs, for example. So the issue's exploding in terms of the amount of Orphan Works we need to deal with. So in a way, books is the exception in that many of them are published in some formal way, whereas photographs just the opposite, right? Okay, so in a nutshell, the Orphan Works proposal, once again, it's 107 pages, very complicated, but well, I've sort of given you some of the basic things about it. Key feature is you have to do a reasonably diligent search for the owner of the orphan work, right? So there's an orphan work out there and you don't know who the owner is. You need to do a reasonably diligent search. Okay, that is the language of tort law, right? As you know, copyright is strict liability. You copy it, you're guilty, that's it, right? So I, as a tort theorist, in general, I'm arguing for incorporating fault principles into copyright. So this is one specific instance of a more broad principle I'm trying to push. Okay, so and this is how I interpret the Copyright Office. They would not say this, they're more political than this. It's not the way to get legislation passed to say, gee whiz, all of copyright strict liability, let's change that, right? But in effect, that's what they're doing by having a reasonably diligent search, right? Because then you can apply sort of an economic approach to that. What is reasonably diligent? Well, it'll depend on the value of the orphan work, the search cost to you, et cetera, all the things you take account of in normal fault liability and tort, right? Importantly, you get rid of what is the killer, what is so-called the thing that creates chilling effects, for example, in a file sharing context. What is it that arguably stops people from creating as much as they should? It's statutory damages, right? It's statutory damages that causes when teenagers are sued for file sharing. That's why the damages are 10 million, et cetera, right? It's because of $150,000 per copying. Whereas under the Orphan Works report, if you do your due diligence, i.e. you're not a faulty user of an orphan work, then the owner, should he or she surface, is entitled to reasonable damages, but specifically no statutory damages. And sort of the end of a sentence, you know, 2/3 of the way through this long report, Copyright Office says, oh, and by the way, oftentimes these will be zero, right? Because indeed, what is the economic harm if you take a photograph or a piece of ephemera or use someone's video and put it on your little YouTube video and upload it? What real harm have you caused? So once you take away statutory damages, there is no real harm in the sense of market harm in the vast majority of uses, right? And that's what the Copyright Office is getting at, so you stop the chilling effect. Okay.
I'm clearing my throat over here now. I have to. I'm sorry. You just have a few minutes.
Okay, good. A few minutes. Okay.
Never say a few minutes to a professor, right?
Yeah, exactly.
Small minutes.
All right, small ones. Okay, I'll talk very quickly.
Don't not quicker, please, because then we won't follow you.
Okay, so this is very subtly radical in the sense that if you think about it, at the end of the day, you'd have a lot more people who were not chilled and would be using orphan works, which are exploding, and in general, owners won't surface, but if they do, they only get actual damages. Well, actual damages are small, and you have to sue somebody, you're not going to do it. So in effect, this is sort of blowing wide open the use of orphan works, right? I mean, that's the reality of it when you sort of cut through 107 pages. Okay, so the question is this better than the Google Books approach under which they would control the orphan works for books, right? So I'm saying, well, let's set aside the question of whether that works for books or not. Let's consider the larger issue of orphan works, right? Which may get thrown under the bus if Google wins, arguably, right? So what I'm saying is that regardless of what happens with Google Books, which I'm a big proponent of, as a general matter, when it comes to orphan works, we should employ this approach, which is to bring fault liability standard into orphan works and real damages. And just one final thought. Since this conference is very provocatively titled, right? Should copyright exist? And coming from the US, right, where it's interesting. So I do normative theory. I did a PhD before law. And my first thought is, gee whiz, moral rights. See, moral rights are the sort of thing, right, that you're endowed with them by nature, right? So in the US, you have this peculiar situation where you're given human rights, right, by the Constitution, yet copyright, it's economic rights. So there's this strange sort of normative thing where particular areas of the law are run economically within a broader system that has moral rights, broadly speaking, when I think about, let's say, a non-US approach to copyright. Okay, so you might think this was sort of oxymoronic. How could you abolish copyright within a moral rights system? That's the sort of question I ask myself. So is it a provocative title or not? So am I sort of, by saying we should move away from the moral rights approach that's now ensconced in non-US copyright law, am I in essence saying you have to get rid of, right, the French Revolution, the rights of man? Is that what I'm saying? No, I'm not saying that. Here's what I'm saying, which is that there's moral rights and there's moral rights in scare quotes. And moral rights in scare quotes are moral rights as they currently exist in copyright systems, and they're rights for owners. And if you think about it, why is strict liability not an immoral thing, right? Generally, tort law moved away from strict liability 150 years ago, and it's thought immoral to hold people strictly liable if they're not at fault. Why not in copyright as well? So moral rights, without scare quotes around them, within the broader sense of non-economic reasoning, deontological reasoning, you can still have rights that aren't within the narrow purview of rights as currently in EU copyright law. And those rights would be things like rights for users who are amateurs to use orphan works if they do their due care. And so if they do actually harm somebody, they weren't at fault in doing it, right? So that's a different view, that consistent with deontology, with moral rights, where you still can get a dramatic change in copyright law. And with that, thank you very much for listening to me.
Thank you so much, Stephen Hetcher. I hope you'll join us in the panel or debate later on.